Was the last time you had employment?
Probably 2 years.
All right, so how are you supporting yourself?
I had came into a trust fund.
Yeah. People in the trust funds, they need to make sure it goes to the right people. I love this movie called The Descendants with George Clooney. And you know what he said when everybody was trying to figure out how much money they're going to get for selling property? He said, one thing you should do with children, he said, you should always give them enough money so that they can do what they want to do, but not enough money so they can do nothing.
Welcome back, guys. Today, Judge Boyd faces
The courtroom opens with a calm but curious tone. Judge Boyd starts by asking about Cadia Pettis's employment, and right away, something feels off. She hasn't worked in 2 years, yet she claims she's living off a trust fund. The judge pauses and delivers a powerful message. Give your children enough to do something, but not enough to do nothing. It's a striking line. Part wisdom, part warning. Who else agrees that this one sentence could change how parents think about money?
a unique case. Cadia Pettis, a trust fund recipient, charged with fraudulent possession of prescription meds. From a George Clooney movie reference to heartfelt advice, this hearing had it all. The big question, would the ruling be strict or forgiving?
Is calling 2025 CR 002575 and 002576, State versus Cadia Brittney Pettis. Can I have the parties announce?
Good afternoon, Your Honor.
State,
Andrew Harris, Edelman.
defense,
John Young.
and are you Miss Pettis?
Yes.
Counsel, in each of these cause numbers, have you received all discovery and reviewed it with your client?
Yes, Your Honor. Yes, Judge.
Did you understand in each cause number you're charged with fraudulent possession of prescription medication as second-degree felonies?
We learn Cadia Pettis is charged with fraudulent possession of prescription medication. Not one, but multiple felony counts. The courtroom atmosphere tightens as the judge explains the penalties. Up to 20 years in prison and heavy fines. But despite the seriousness, Pettis remains calm and polite, answering every, "Did you understand?" with a quiet, "Yes, ma'am." The judge's tone stays professional but firm. Viewers, do you think she truly understands the weight of what's happening?
Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, ma'am.
Did you understand in each of the cause numbers, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you?
As the formalities continue, Judge Boyd carefully walks Pettis through her rights. The right to a jury trial, to remain silent, to appeal. Pettis waives them all. It's almost procedural, yet beneath the routine, there's tension. The judge confirms she's entering a no-contest plea, meaning she isn't admitting guilt, but she's not fighting it either. That small phrase carries a heavy truth. Sometimes silence speaks louder than denial.
Understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Miss, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, the state is recommending deferred adjudication. They will take in consideration 2025 CR 002578, 2000.
The courtroom tone softens for a moment as Pettis's lawyer asks for her probation to be transferred back to Illinois. The judge inquires about her life, her child, her work, and how she supports herself. That's when the trust fund story comes up again. The irony isn't lost. A woman charged with fraud now discussing money she didn't earn. It's a reminder that privilege doesn't always protect you from poor choices. What do you think? Is the trust fund helping her or holding her back?
2025 CR 0025579, 2025 CR 0025881. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only evidence that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years and there be no contact with Walgreens. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in each cause number, how do you plead?
No contest.
State in each.
Judge Boyd returns to the movie quote from The Descendants, using it as a life lesson. The courtroom, though serious, almost turns into a classroom for responsibility. The judge makes one thing crystal clear: everyone on probation must work. No free rides? Pettis nods in agreement. It's a moment where wisdom meets accountability, and the judge's message lands perfectly.
Cause number, any evidence?
Contained in Exhibit 1 and attachments, Judge. No objection, Your Honor.
State you may be excused. Did you review the waivers with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Now comes sentencing. The verdict: 6 years of deferred adjudication. That means no jail time if she stays clean and follows the rules. Pettis can serve her probation in Illinois, but only after approval. She's ordered to find a job, take parenting classes, avoid working near children, and perform 200 hours of community service. The terms are strict but fair. Viewers, would you call this justice or mercy?
My client resides in Chicago, Cook County, Illinois, Your Honor. We would request that the probation be transferred to that location.
All right. What brings you to San Antonio?
I don't know. I have no.
Oh, you have warrants here? So
Yes.
was she transferred from?
From Chicago, Your Honor. She was taken into custody there, I believe, on the 1st of December
Yes.
and was transferred here.
Do you have any children?
Yes.
What are their ages?
11.
So you have one child,
Just one.
all right? And
Yes.
who is your child with now?
His father.
And when's the last time you had employment?
A what?
When was the last time you had employment?
Probably 2 years.
All right, so how are you supporting yourself?
I had came into trust fund.
People in the trust funds, they need to make sure it goes to the right people.
Judge Boyd doesn't stop there. She adds something rare: a human touch. She explains that success on probation depends on communication, honesty, and effort. If there's an issue, tell your probation officer, she advises. It's a small but powerful moment. The judge isn't just punishing, she's teaching. She's offering Pettis a roadmap to redemption.
Here's the thing. I love this movie called The Descendants with George Clooney. And you know what he said when everybody was trying to figure out how much money they're going to get for selling property? He said, one thing you should do with children. He said, you should always give them enough money so that they can do what they want to do, but not enough money so they can do nothing. So in this court, when people are on probation, I require that they have employment. You understand?
Yes, ma'am.
All right. In each cause number, the court will sentence you to 6 years deferred adjudication. There's to be a transfer to Cook County, Illinois. What I can tell you about that transfer, you're not on probation out of Cook County until probation grants you leave to go to Cook County. You understand?
Yes, ma'am.
There's to be regular reporting by Zoom or in person, regular random UAs,
Before ending, Judge Boyd checks every detail: education, mental health, community service, contact restrictions. It's clear she's protecting not just Pettis, but society too. When Pettis confirms she graduated high school, the judge encourages her to go further, earn a certificate or degree to reduce her service hours. It's accountability balanced with opportunity, something we don't see in every courtroom.
Proof of employment within 30 days. No employment as a home health care provider or with minors. And so what were you doing with these drugs?
Taking it.
What, ingesting them yourself?
Yes.
All right. There's to be a TAP evaluation in custody. Follow recommendations. There's to be no unsupervised contact with minors. There's to be 200 hours of community service restitution. How far did you go in school?
High school.
Did you graduate?
Yes.
All right. I'm going to order parenting classes. 100 hours will be deducted upon completion of parenting classes. And the remaining 100 hours will be deducted if you obtain a higher level of education or if you obtain a certificate from some sort.
With the paperwork done, the judge leaves one last piece of advice echoing through the courtroom. To be successful on probation, communication is key. It's a simple truth, yet one many forget. Pettis quietly nods, perhaps realizing she's been given not just a sentence, but a second chance. The tension finally breaks as the case closes, but the message lingers. Growth begins when excuses end.
Of trade school. Field visits 1 time per month until further notice. Probation, is there anything else? And I'm sorry, in taking consideration 2025 CR 002578, 002579, and 002581.
May I approach the judge?
Yes. The document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you sign it and understand it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record in this court. To be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right.
So guys, Pettis walked away with
So Cadia Pettis walks away with 6 years of deferred adjudication, not prison, a chance to rebuild her life. Judge Boyd showed the perfect mix of discipline and compassion, proving that justice doesn't always mean harshness. Sometimes it's about guidance. But what do you think? Was this outcome fair or too forgiving? Drop your thoughts in the comments, and don't forget to like, share, and subscribe for more real courtroom moments and emotional verdicts that make you think.
6 years of deferred adjudication, a chance to change. Judge Boyd balanced compassion with accountability, reminding her that responsibility is key. What do you think? Was this fair, or should the sentence have been tough? Drop your thoughts below, and don't forget to subscribe for more real courtroom moments.